This is the Financially Simple Podcast, the show dedicated to destroying the complexities of money for today's small business owner. The content in the show is for informational purposes only. This show is not investment advice. Instead, seek help from a competent financial advisor or conduct your own due diligence. Justin Goodbread, CFP, is an investment advisor representative of Heritage Investors, a registered investment advisor only conducting business in states where it is properly registered or is excluded or exempted from registration requirements. Registration is not an endorsement of the firm by securities regulators and does not mean the advisor has achieved a specific level of skill or ability. Here's your host, pizza-loving, certified financial planner, Justin Goodbread.
And welcome back to the Financially Simple Podcast. I'm your host, Justin Goodbread, and today we're going to continue with our discussion that we began in the last episode, talking about our last will and testament. Today we're going to cover some key points you may want to consider when dealing with your last will and testament. Now remember, like I said last episode, I'm not an attorney. I work with a number. I did not stay in a Holiday Inn Express last night, if you remember the old commercial. That's not who I am. But I have 25 plus years of business experience, and I have sat in countless hundreds of last will and testament creation meetings. So I want to bring some real world experience, some in the trenches experience to the forefront and give you about 8 or 9 different points here that you may want to know or you may want to consider when drafting your last will and testament. Let's go through these in order, and we'll try to make this a shorter episode. Number 1, make sure you use the full accurate names on the document. Misspellings here can kill you in court costs, or they can cause you additional court costs if nothing else. So if you remember, you're going to name a guardian, an executor, and trustee. You're going to name those individuals to help carry out your wishes. We talked about that in the last episode. Do not misspell the names of the individuals. Now, that's hard for me to say, being I can't spell hardly anything. Probably can't even spell anything if you ask me to. But the goal here is to make sure you have the most accurate spelling, the correct spelling of the names. Because we're just trying to prevent court costs. I've seen people where they didn't do this and they had something misspelled, and now we got to go through the gyrations to prove that the correct spelling on the name is accurate. Number 2, try not to use the word "and" when denoting or nominating or appointing a guardian, an executor, or a trustee. Let me explain. Let's talk about the executor. That's the easiest one. Let's say my mother were to leave my brother, my sister, and I as executors. Do you know how hard that would be? I'm in Tennessee. My mother lives in Georgia. I would have to deal with consistent logistical issues. Let's say we lived in even a further distance. Logistics would create problems. What happens if we don't agree on something? The "and" there creates a potential hazard. I've seen this. I've seen where so-and-so and so-and-so are the executors, and they get into a squabble. Brothers and sisters get into a squabble. Imagine that. Somebody that you love just died, and emotions are running wild, and logic is out the window. We've all been there. And now you have to make joint decisions and agree with somebody who you should be fuming mad at. Yeah, it's not a good idea to use the word "and" when you're explaining a guardian, an executor, or a trustee. Now, I have seen where "ands" work. I have. What I'd like for you to do, if you heard where somebody said "and," then maybe they named a guardian, Fred and Wilma as the guardian of their kids, or Tim and Sam as the executors, or dual trustees. Hey, shoot me a little message on Twitter, Facebook, LinkedIn, even Instagram if you want to, and say, "Hey, Justin, I heard this in the episode here, and I've heard where "and" is a good thing." I don't hear many attorneys who will say that. Maybe you're an attorney out there who's listening to this. I know we have a couple hundred attorneys that I know of that listen to the episodes. Let me know if you agree with that, if that you try to stay away from "and." Just tag me on social media somewhere. Point number 3 is know the difference between Per Stirpes and Per Capita. So let me explain those. Per Stirpes, I'm not saying a bad word here. It's actually a Latin word that basically means that the grantor, the person who creates the legal document, that'd be you if you're creating your last will and testament, intends that the beneficiary's share of the inheritance will go to his or her heirs. Let me put some teeth on this. Let's say my mother and I are driving down the road and we get hit by the proverbial log truck. You know, the same log truck I introduced last episode. Let's say my mother has left me 1/3 of her estate. Because my mom has 3 children who are living, let's say that she were to leave me 1/3, my brother 1/3, my sister 1/3, and then mom and I are gone. Does she intend for the money that she would have left me, or my portion of the inheritance, to go to my children, my Savannah, Justice, and Jude? If she intends that, so my proportionate share would go to my beneficiaries, then she would use the term Per Stirpes. Now, if she intended that her money only stays with her living relatives or those who she expressly names, she would use the term per capita. Per capita means that she, my mother, the grantor, intends that no one else except for those who are named received the share of the estate. Okay, so that's the difference. The attorney's going to ask you, well, do you want this estate to go to your children if something happens? That's per stirpes. Or do you want this to only go to yours and no one else? That's per capita. So there's a difference there. Number 4, don't forget any assets. I know that seems logical, but friends, I've seen some crazy assets that people forgot about. I've seen people forget about a tract of land somewhere. Timeshares, they're an asset. Well, it may not be a good one, but they're an asset. They're difficult to deal with sometimes. Trying to sell them, you almost have to give them away depending on where it's located. I've seen where people forgot about a timeshare and it opened the estate up some 6 years after it was closed. It was a nightmare. So don't forget about your assets. Before you go meet with the attorney, write down everything. Don't be ashamed. If it's good or bad or whatever you want to relate it to, tell them everything so they can give you guidance on how to deal with the transition of those assets. Number 5, what do we do with the money we're leaving our minor kids? So in my will, I have a thing called a testamentary trust. Testamentary means that the instructions are created in the will and it creates at my death. So there's a trust that is irrevocable, means it cannot be changed, that goes into effect at my death. And theoretically, let's say that I had $3 million of assets. And I wanted my assets to go to my children who are minors. Me and Emily's out of the picture and we want to leave them all $1 million each for mathematical purposes. How do you give the money to them? Well, there's going to be a trust and they're minors. So underneath the trust rules, it's going to tell them that we can distribute money for HIMSS, and that stands for health, education, maintenance, and support. Thus the word HIMSS. We can give them money from HIMSS, or the trustee can distribute some money for that purpose unless we denote otherwise. But what are we going to do when they turn 18 and we're going to give them $1 million plus? Think about that. I've had people in my office who've had $20 million, $30 million per child. Man, I hear over and over, Justin, I do not want to create a trust baby. This money is a blessing, but it's also a curse. How do I deal with it? I don't want to leave this much money to my kids. I don't want to take away their drive. I don't want to create dependence. I don't want their talent wasted. I want them to go out and try to build their own future. Friends, I've heard it all. And to some point, I agree with that. I think that if God blesses us, great. I think you ought to leave an inheritance. I think the Bible talks about that. But I also believe that we can incentivize our children. I read one time where someone said, well, whenever the kids are over the age of 18, if they want to start a business and they make $100,000, we'll distribute $100,000. We'll match whatever they earn. I've heard that. I think it's a brilliant idea. I've heard people say, well, when they're 18, we'll give them some money. And then whenever they're 60, we'll give them some money. That may be an idea for your family. Whenever I was doing my legal documents some 12 years ago now, 10 years ago, there was a wise attorney who's since passed. Loved him to death. Great guy. He had a temperament that was amazing to me. And me and my young, ignorant, rambunctious self, he said, Justin, whenever you leave this much money to your children, let's be wise with it. I can remember those words like it was yesterday, just exactly like that. He said, let's be wise with it. He said, why don't you do this? Whenever your children reach age 25, they should be done with college. We've already provided for their college out of the trust based underneath the HIMSS metric, health, education. So we paid for their education out of the trust. And now there's some money left over. Whenever they're 25, let's give them some money. Let's give them 1/3 of whatever's in the trust. And I'm going, 1/3? Have you lost your ever-loving mind? If there's $1 million, that's $300,000, $333,000 to be exact, and some change. He said, yeah, let's give them 1/3. And let's let them go create success. And I said, but what if they mess it up? He said, yeah, let's play all the what ifs. What if they mess it up? What if they lose it all? What if they go through a divorce? What if they try to invest in a business and it falls apart? What if? He goes, okay, whenever they're 35, you're going to do it again. Like, what? He goes, yeah, you're going to give them the remaining 2/3. Now it'd be 1/2 at that point of the trust. I'm like, man, you've got to be kidding me. He said, no, let your kids go out and create something. Let them give it away if they want to. And Justin, when they're 45, you're going to close it out. Now, I personally did that. I don't know if it's right or wrong. Emily and I have been talking about changing that with just some things we're dealing with, but that's an idea. I've had individuals in the office who say, all we're going to do is distribute the income, and they try to create what's called a dynasty-style trust. Now, there's rules and all that regs that go with that, but they just want to create the income. My point is this. The attorney is going to ask you questions along, how do you want to distribute the money to the kids? And that is a hard decision because, like you friends, I want my kids to excel past me. I want them to be able to conquer whatever God puts in their life. I really do. I don't want them to have money be a hindrance. Like, Justin, there's no way. Friends, yeah, there is. I see it happen so many times. I've watched money destroy families. I've watched kids get into drugs and craziness because of just too much money. So this is one of the hardest things that you're going to deal with. And probably it could be very well a reason why many of us don't have the wheels in our life that we need.
You're listening to the Financially Simple Podcast. Show your support by subscribing to this and our other educational business channels at financiallysimple.com.
Let's move on. Number 6. You want to make sure that you execute the will properly. What do I mean? Well, the attorney's going to have you a place to sign it, but I prefer to have every page initialed. I like to use blue ink. A lot of attorneys that I know will do the same thing. They'll have you sign in blue ink so you can denote originals, and they'll have you initial every page. Sometimes they'll have an initial and date every page, and if there's any scribbles, they'll have you initial and date those, and they'll have you sign those. So make sure you sign it properly. Some states will require notaries. Some do not. So your attorney will help you here. Now, don't forget to update your will. Yeah, I'm talking to you folks who've had your will for 10, 15, 20 years. It's time to update it. Well, Justice, nothing really's happened. Yeah, there's a lot that's happened. The Terry Schiavo case back in, I think it was 2000 and might have been 5, 6. I can't remember when Terry Schiavo dealt with it. Man, it changed the estate planning world. We've had the estate laws change drastically, and they probably will again. More than likely, if you did your will some 15 years ago, your kids are no longer the same, or maybe you now have additional kids you didn't name. You might even move states. Maybe you had a will that you did down in Georgia. Now you live in Tennessee like me. So don't forget to update your will. Well, how often do you update it, Justin? Whenever major life events happen. Monumental life events happen. You have a new child. You go through a divorce. You create a business. You move, et cetera, et cetera, et cetera. And finally, number 8. We have this document now that we've created. What in the world do you do with it? I'm asked this question often. Well, Justin, where do I put this thing? Well, there's a couple of choices you have. One place you could place it is at the executor. You could give it to the executor. Now, there's some risk involved because the original is what you want to have. The court's going to often ask for the original. You can give it to the executor if you trust him, place it in a sealed envelope and say, if I die, open this. The executor could store it in a safe place. They could store it in a safe deposit box or in a personal safe at their house. If you change your mind in the future, you could actually change your executor, or you could give the executor a new document. Not a bad way to go. You just got to make sure that the executor is trustworthy. Another place you can do it, and probably one of the most popular places you could do this, is actually keep it in your house. Now, my guard against keeping in the house is make sure it's somewhere that's protected from fire and weather. A lot of people will use safes, like these little handheld safes, or a safe in a safe. If you're going to use a safe, make sure that somebody has the code to the safe, okay? Yeah, I've dealt with that too, where no one had the code to the safe, and we had to get a locksmith to come in and open the safe. Some people have actually used what's called the poor man's safe. That's where you take the will, put it in a freezer bag, and throw it in the freezer. Not typically recommended, but people do it. One of the things that most people like to do is use a safe deposit box. Safe deposit box. Now, I am not a fan of using a safe deposit box. Here's what happens. If you and your wife, or you and your business partner, whoever you're on the safe deposit box, you put your will in there and you die. And now the executor says, I'm going to go to the bank and I'm going to open the safe deposit box. The minute the bank becomes aware of your death, more than likely, they're going to secure it. They're going to shut it. And now you, the executor, or your executor, will have to have a court order to open it to see where the will's at. Just not a big fan of that. I've dealt with that probably a half dozen times in my career, to where Somebody put a will in a safe deposit box. They died and no one can get to it now. So we got to go to the court. It's just a hassle that you shouldn't have to deal with, but it's there. So a safe deposit box is not a good one. You know, one of the best places you could do is let your attorney keep it. You could let your attorney keep the original will and then just denote on a copy that whatever law firm has it. Now, it's common for lawyers to dissolve a firm or move. So if you're dealing with a smaller law firm, it could be very difficult for the executor to locate it years removed. So maybe you move from one state to another or move across the state and the law firm moves away or they change the name of it. That can be pretty difficult. So, but it's nonetheless a place you can go. Believe it or not, another option you could do is some probate courts allow you to go ahead and file your will with the court. If you're in a city that does that, not a bad place to go. You go ahead and file it. Now, if you move to another jurisdiction, it may not help you. It may not help you because you have to refile in that jurisdiction. If you change your will, then you got to go and refile it with a new will. And finally, digital archives are available. Some states will allow digital archiving. Some states will not. A probate court may not accept a printed copy. So you got to make sure your particular state location. This is where a good attorney comes to play. So I've just given you some 8.5, a little bit more examples under each of those 8 points from real life in the trenches, things that you can look at with your last will and testament. I hope that helps you. Look, life is hard. It is. Life is hard. Making decisions on what you're going to do with money, what you're going to do with your children. Friends, I don't think there's a harder thing we can make a decision on in our life. What you're going to do with those things that God's entrusted you with is tough. But life is good, and life can be frustrating. Hey, money doesn't have to be. Let's continue to make our lives at least financially simple. Hey, y'all go out and make it a great day.
You've been listening to the Financially Simple Podcast. For more business and personal financial help and information, head over to financiallysimple.com today.